Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields. Welcome and good afternoon everyone to Business Legal Lifecycle TV and for those listening on the podcast. Today we're doing our monthly legal update for September 2018, so welcome. I'm Jeremy Stretton, one of the founders at the Business Legal Lifecycle, and with me is Craig Mason. Say hello, Craig.
Hi everyone, thank you for joining us. Hopefully you get a lot out of today's legal updater show for September.
Great. Thanks, Craig. So today, as always with our monthly legal updater, we're going to be going through the top legal changes from Australia and around the world that affect businesses. So we're going to look at what the actual change is and then what it means for you. So Craig, do you want to kick off with the first one?
Yeah, the first one is regarding casual workers, and this is in Australia. So there was recently a ruling that has granted a casual worker annual leave entitlement. So usually it's a position that casual workers are not entitled to annual leave because they get an uplift in their casual rates. So a truck driver was employed as a Rio Tinto at the mine, under a labour hire arrangement as a casual. So the full federal court here in Australia found in August that the truck driver was not a casual under employment law because of his regular and continuous pattern of work. So under the Fair Work Acts and the National Employment Standards, a casual employee is not entitled to annual leave, which a permanent employee receives, as I said. So there's no actual definition, unfortunately, of a casual employee, so it was really up to the judges in this instance to work it out. So they found that a person was an employee under the definition of an employee and not a casual employee, so the mine driver. The court did acknowledge the difficulty in characterising casual employment, so they've recognised that. However, they ultimately reiterated the idea of identifying the essence of casualness, and the indications were that the absence of a firm advance commitment as to the duration of the employee's employment or the days the employer will work, so this is casualness. No firm advancement commitment from the employer to continuing an indefinite work according to an agreed pattern of work, and the casual employee will also not provide a reciprocal commitment to the employer, and no regular work patterns. There's uncertainty, discontinuity, intermittency of work, and unpredictability. Importantly, in the case there was no evidence before the court that the person was paid casual voting at all, and the court found that the National Employment Standards take precedent over anything that is in an agreement between the parties. So what does all this mean? This has been a long a controversial area of the law, and as the judges admitted that there is difficulty in characterising casual employment, so that's great for all of us employers out there. Given the lack of legal definition of casual worker, it is clear that the court is taking a narrower approach to that definition now. a lot of businesses obviously need to look at their employee arrangements to make sure that they don't fall foul of this ruling. So if you've got casual employees, you need to have a think about the sorts of things that are the essence of casualness that I spoke about before in that case. So if you've got casual employees, I suggest you seek some advice about that to make sure that they are truly casual staff members. So pretty important ruling here in Australia for employers. Jeremy.
Yeah, thanks, Craig. So the second one that we're going to talk about, we're going to go across the ditch to New Zealand. So hello to all our New Zealand viewers and listeners. And this is changes to the foreign ownership of property in New Zealand. So the New Zealand Parliament has passed a law that bans non-resident foreigners from buying existing homes. So this was an election pledge. The new Labor government that came in, I think it was earlier this year in 2018, might have been late 2017. But basically it's been brought in as an effort to stop the quickly rising property prices in New Zealand. Foreign ownership has attracted criticism in recent years because New Zealand's been grappling with a housing crunch that has seen average prices in the largest city of Auckland almost double in the past decade and rise more than 60% nationwide. That's a large thing. And we know that in Australia, that's a similar concern. Whilst we haven't banned foreign owners, people buying, we have put measures in place that we've talked about in previous legal updates of foreign residents who buy land here having to pay extra stamp duty and things like that. So whilst Australians, and we're Australians, so this is important, are one of the largest purchasers of land, we are actually exempt from the new laws. The effect of this new law is actually mainly on Chinese buyers. They're equally, with Australians, the biggest foreign buyers of land in New Zealand. And so the Parliament's been very concerned about Chinese people buying up properties, so that's why they've brought in the law. This isn't a political show. What does it mean? We're just telling you the facts as they've been reported. What does it mean for you? It's something that the International Monetary Fund has criticised, and they've warned that moving this to discourage foreign direct investment will have a serious impact on the country, and it might also affect the ability of people to build new homes. It means that if you're from a country that's outside New Zealand or Australia, then you probably can't buy property in New Zealand. So if that's something that you've been looking at doing, then you might need to reassess your investment ideas. There may be ways of getting around it. We're not experts in New Zealand law. Talk to a New Zealand lawyer, because you never know, there might be ways to get around the ban. But you need to have a think about that. At the time of the recording, so this is in September 2018, the New Zealand government is also negotiating with Singapore that will put in an exemption for Singapore buyers as well. So I think this is something really important to just be aware of. It's something that is happening more and more around the world, especially in Western countries. There's a concern over property prices. There's a concern over foreign investment in their countries. So what we're seeing more and more is governments taking drastic measures to actually try and curb property price increases. Hopefully this is the only real time that we're going to see this happen. I think that foreign investment's great, but I do also appreciate that from it can increase prices, which can exclude people from buying properties. So just be aware of this change in New Zealand. Be aware that might change in other countries like Australia, like the UK, like the United States. So if you are looking at investing in foreign property, that you do it sooner rather than later, because it's unlikely in countries like those that once you've invested that they'll force you to sell the property. It's more likely that they'll just prevent further purchases. So that's the second one. Craig, do you want to do the third?
Yeah, the third one we wanted to touch on, and this is an interesting one and not something that I think was expected. There's less food delivery outfits in Australia. Fedora has recently shut down their operations in Australia, so there's less scooters out there delivering our food. Fedora announced it was doing this because it wanted to focus on other markets, apparently. Now, administrators have been appointed to the company that ran the business. However, it's been revealed recently that the Australian Tax Office, the Fair Work Ombudsman, Revenue New South Wales, and a former worker are all pursuing Fedora for debts. So essentially there's more to the story by the sounds of it. It's intriguing that when the Fedora pulled out of Australia, they mentioned that they were solvent. However, as I said, there are now a number of actions against them. So interesting to see what happens next in relation to Fedora. As I said, not something that I would expect Fedora to shut down all their operations in Australia, but they've done it and they're off to a different market. So no more Fedora.
That's a shame.
Yeah.
All right, so the last of, before we get into ASIC and the ACCC, is one something that's been recently announced, and that's the Huawei, the Chinese-owned tech giant, has been banned by the Australian federal government from taking part in the 5G mobile infrastructure set up in Australia. The reason that was given was national security concerns, and the government said that it was disqualified as it was likely subject to extrajudicial directions from a foreign government, obviously China, that conflict with Australian law. So what does this mean? We've talked about this before on Business Legal Lifecycle TV, the importance of 5G. We're running a Facebook Live show that we have to run through cable internet and sometimes on the national broadband network because normal internet is just too slow. If you see problems with our feed, if you're watching it live, you'll notice that from time to time we might struggle with the internet, and that's because the internet in Australia just isn't up to standard. And it's a real shame that anything would come to preventing 5G from coming out. 5G is the next generation of mobile technology that is promised to substantially increase speed. So, whereas 4G has speeds of up to 100 download and 20 upload, 5G is meant to be in the gigabytes a second, which is something that's sorely needed in Australia. The networks, as I said, is just too slow. We should be able to run these kind of things without that kind of impediment, and really, it's something that needs to be fixed, and that doesn't mean just because this company's been banned that it's going to slow it down. Although they said that it would, but it's something that Australia sorely needs, and hopefully Telstra and the other giants, telecommunications giants, get 5G rolling out and don't delay it anymore, because it would be a real shame to slow down the rollout of 5G, because in 2018 we're using more and more bandwidth, and it would be great to see that being reflected in the technology that we have in this country. Craig, do you want to move on to the news from ASIC and the ACCC?
Yeah, over to the ASIC and ACCC corner for this month. So the first one is regarding ASIC. A former director of some companies, Mr. Adam John Copping, he was convicted of dishonestly using his position to fraudulently remove company property. So Mr. Copping was a director of a company that was placed into liquidation in March 2016. However, he fraudulently removed a truck that belonged to the company without actually providing any consideration. So the liquidators provided a report to ASIC, and ASIC took some action and prosecuted the person. He was convicted and fined the sum of $2,500. So that's what ASIC's doing. Also with ASIC, they've approved the Australian Banking Associates new banking code of practice. Obviously, we're not going to go into all the detail of this new code because it's quite lengthy, but it provides improved protection, particularly for small business borrowers, and expands the reach and impact of legal protections against unfair contract terms. So it's an interesting development and expansion given the Royal Commission into banking that was conducted and may even still be going. It doesn't seem to be in the news anymore, so I'm guessing it's over, but the recent Royal Commission into the banking sector. So ASIC have approved the Australian Banking Associates new banking code of conduct. So that's it for ASIC. Jeremy, I think you've got the ACCC, do you?
I do indeed, yes. So there's two from the ACCC. The first one is the ACCC reported that the Federal Court of Australia has declared by consent that Palaram Australia and Appellite Australia engaged in exclusive dealing conduct. So I'm not going to go into what exclusive dealing is, but essentially it's a breach of the Competition and Consumer Act for having an agreement where you exclusively deal between parties. I'll give you the example that'll probably explain it better. But both of these companies distributed roofing products to retail stores under different brands. And these are roofing products that are usually used to build pergolas. Both companies agreed to an acquisition and then there was a condition that another company would not compete with them. So this is a breach of the exclusive dealing, because essentially they're saying, we'll agree to this acquisition if this company doesn't actually compete with us in this, and becomes, it's an anti-competitive part of legislation. The court has ordered them to pay $5.5 million in penalties. So that's a significant fine, especially for two companies. It'll be interesting to see whether or not that's appealed. We'll let you know if we hear anything more. But it's something to be wary of, that there's breaches of these acts that go on all the time, but the ACCC is onto it, and they actually do prosecute, and then you do get hefty penalties from them for breaching this kind of conduct. The second one, and we've actually reported on this one before, and that's Heinz Company Australia. And they've actually, if you remember from an earlier show, we talked about the fact that they've been found guilty of misleading conduct and making misleading health claims that its little kids' Shreds products were actually beneficial for young children. So Heinz was found to have breached the Australian consumer law, and by claiming that the Heinz Shred products were beneficial for the health of children 1 to 3 years. This was untrue, probably because of the sugar that was involved in their products. Craig and I both have young children, so we know all about that. And they've been ordered to pay a fine of $2.25 million because of that misleading claim. So once again, the ACCC is going after businesses and people who do mislead and deceive, and it's really important that you get these things right, because if you don't, then they will come after you. So that's it from our legal updater. Craig, do you want to finish off the show?
Yeah, absolutely. Thanks everyone for joining us. We'll be back again next month for this show. So if you've got any legal updates that you've come across or will come across over the next month or so, please let us know. We'd be happy to look at them and see if we can include them in the next show. We'll be back again for Fast Fix Monday, on Monday obviously. So join us then. We'll be talking more about Phase 5 intellectual property. If you have any feedback on this particular show, please let us know. Comment on Facebook or send us an email, whatever it is that you can. There will be the notes on this show on the website as well. It's show number 127, so it'll be businesslegallifecycle.com.au/127. So if you're interested in that, get on the website, check out anything else that's on the website as well. All the other shows are on there, so read through the notes at your leisure. But thanks for joining us, and we'll see you again next time.
See you next time.